Welcome to AITV News. Today, we're examining a decision by the United States Supreme Court to not hear a challenge against Maryland's ban on certain semi-automatic rifles. We'll explore what this means and the wider context. The United States Supreme Court recently, on June 2, 2025, declined to take up a challenge to Maryland's ban on specific semi-automatic rifles, often referred to as assault weapons. This decision means the Maryland ban, enacted after the 2012 Sandy Hook Elementary School shooting, remains in effect. As is common, the court did not provide a detailed explanation for turning down the case, which was Snope versus Brown.
Maryland's law, the Firearm Safety Act of 2013, was passed following the tragic Sandy Hook shooting in Connecticut, where 20 children and 6 adults were killed. The shooter in that incident used an AR-15 style rifle, a type of firearm covered by such bans. Maryland's law prohibits various firearms, including the AR-15 and AK-47, and also limits gun magazines to 10 rounds. Those challenging the ban argued it infringes on their Second Amendment right to own firearms, emphasizing that these rifles are popular and widely used responsibly. Maryland contended that these weapons are not protected by the Second Amendment because they are similar to military-grade weapons and are not well suited for self-defense.
Although the Supreme Court didn't take this specific case, several justices shared their views. Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch publicly stated they would have heard the case. Justice Thomas wrote a dissent, arguing the Maryland law likely infringes on the Second Amendment, and highlighted the AR-15's popularity among millions of law-abiding owners. Justice Brett Kavanaugh, while agreeing not to hear this particular case at this time, expressed skepticism about the constitutionality of such bans in a separate statement. He suggested the court might address the issue in the next term or two, noting that millions of Americans own AR-15s, and that states prohibiting them are something of an outlier. This isn't new for these justices. As an appeals court judge in 2011, Kavanaugh dissented against a similar District of Columbia ban, and Justice Thomas dissented in 2015 when the court declined a challenge to another local ban on AR-15-style weapons. This decision is noteworthy as it follows the Supreme Court's 2022 ruling in New York State Rifle and Pistol Association versus Bruin, which expanded Second Amendment rights. That ruling instructed lower courts to assess gun laws based on the nation's historical tradition of firearm regulation. This has led to many challenges to gun laws and some confusion in lower courts. Currently, about 10 states, including Maryland and the District of Columbia, have bans similar to Maryland's. A federal ban on assault weapons expired in 2004, though some Democrats support its renewal. On the same day it declined the Maryland case, the court also chose not to hear a challenge to Rhode Island's ban on high-capacity magazines, with Justices Thomas, Alito, and Gorsuch indicating they would have taken that case as well. In other recent gun-related actions, the Supreme Court in June 2024 struck down a federal ban on bump stocks, attachments that allow semi-automatic rifles to fire more rapidly, ruling the ATF exceeded its authority. Also, in June 2024, the court upheld a federal law that prohibits individuals under domestic violence restraining orders from possessing firearms in the case United States versus Rahimi. More recently, in March 2025, the court upheld federal regulations concerning ghost guns, which are untraceable firearms assembled from kits, in Bondi versus Vanderstock.
So what's next? While this challenge to Maryland's law was declined, Justice Kavanaugh's comments strongly suggest the Supreme Court may address the broader issue of semi-automatic rifle bans in the near future. This complex legal and social debate is clearly ongoing. That's the latest on this Supreme Court decision. Thank you for joining us at AITV News.